Alrighty, folks, we are live. This is George, founder of Solo, and this is the Debt Hotline. Today we have our friend John Skiba on. And John, very good to have you on.
Yeah, I'm excited to be here once again. Love coming on the show.
Fantastic. John Skiba is an experienced bankruptcy and consumer rights attorney and owner of Arizona Consumer Law Group, PLC. He has helped more than 10,000 families struggling with overwhelming debt issues. He runs the Consumer Warrior YouTube channel with more than 70,000 subscribers and helps educate consumers on their rights, how to settle debt, how to file bankruptcy, and how to deal with debt struggles. So again, John, happy to have you on. The initial topic for today is how to settle credit card debt in 2025. So John, what's the main process for settling credit card debt?
Well, I mean, a lot of it will depend. I mean, there's a lot of different factors that go into how good of a settlement you're going to get, how low you can get it. But I always say the overall arching principle of all of this, you got to look at it. If the credit card company, the debt collector, they want money. If you're offering money, there's got to be some middle ground. That's how I always approach this, that there's got to be something we can get done here. The big thing is communication. Too often I see people avoid communicating with either, phone calls, the debt collector, they're getting letters in the mail and they don't do anything. The longer things go on, often, the worse they can get as far as, then it results in lawsuits and potentially judgments and garnishments. Often here in my law practice in Arizona, people will call me, and once they get to the garnishment stage, at that stage, negotiation is really tough. All the leverage is with the creditor, and really there's not a whole ton other than like a bankruptcy option that you get. So my recommendation, if you're looking to settle the debt, if you're looking to avoid dealing with lawsuits and bankruptcy and everything else, early communication is key. Even with the original creditor, before they charge it off or sell it, is reaching out to them and just saying, hey, what's available? I've been surprised at some of even the big banks, people who are current come to them and say, look, I have this hardship situation. I'd like to try to get this resolved. I'd like to try to get it settled. What can I do? And, they may not give something that's perfect, but sometimes I'm surprised at the options that if you're communicating that they do offer even early on in the process.
Fantastic tips. Yeah, good to know, right? People can settle at any step along the way in collections, right? You can oftentimes get a deal and resolve things at any point in the process. Folks, if you have any questions today, just call the debt hotline. You can reach us at 801-613-8181. So if you have any questions, call into the hotline at 801-613-8181. You can just call us right now. We can plug you onto the show and you can ask us your questions. We can help you out with whatever your situation is. We also have people who have written in some questions ahead of time. So I will start off with some of these questions. But if you have a question you're watching, we have lots of people listening in on the show today. So if you have a question, just call 801-613-8181. That number is here on the bottom of the screen. So we have our first question from Eric in Ohio. Is it better to wait a few more years for the statute of limitations on debt? Is there a way to clear these off your credit after, or will you still technically owe them even after the statute of limitations has expired?
Yeah, I mean, it's a good question. I mean, the statute of limitations is the amount of time that a creditor has to file a lawsuit. Really, it usually starts running roughly 30 days after the payment is due. You're technically in default at that point. And the statute of limitations varies from state to state. In a lot of states, like here in Arizona, it's 6 years they have to file the lawsuit. And even if the statute of limitation has run, if it's expired, the creditor can still try and ask you to voluntarily pay. Now they've lost some of their, the teeth, they've lost some of their hammers to come after you because they can't sue you anymore. And because of that, if it's outside the statute of limitations, your settlement offer should be lower. And they'll be willing to take less because there's not a whole lot they can do other than, saying, please, will you go ahead and pay this to us? But because the statute, I mean, in some states, the statute of limitations can be 10 years. I mean, so it can be a long time that you're dealing with this, where it's impacting credit score overall. So like I said before, I don't think there's any downside to trying to communicate to resolve the debt, try to settle it even early on. Something that a lot of people worry about is, maybe the potential impact if they do get sued later. There's a rule of evidence if a lawsuit is filed that states that settlement discussions are typically not admissible in court. And the reason why is because the courts want the parties to talk and try to negotiate and get something done. So I don't think there's any downside to reaching out. I usually recommend you come up with an offer, something that you can propose to the creditor. It's rare when I'm negotiating with a creditor that I can call up the creditor's attorney and say, hey, what'll you take? And they're going to say, well, provide me an offer and then we'll take it to our client. So it's something you need to look and kind of determine what your settlement budget, how much you think you can afford, whether a monthly payment, lump sum, and then go to the creditor, maybe see what options are available and present that settlement proposal and see what kind of response you get to it.
Love the people on Facebook Marketplace that text me and say, what's your lowest offer? How low can you go right out of the gate, right? I mean that sarcastically because I just tell them the list price, right? It's listed for $500.
Yeah, exactly. Same
to negotiate myself down. Right. Yep. Same idea here. Right, folks, if you want to get a deal, you have to determine what you can do. And also, right, nobody is more of a professional negotiator than a debt collector. They do it all the time. They're most interested in the facts of your situation, most interested in your actual facts, right? They're not interested in your wild, crazy story, right? It's not so much that you got into a medical situation that you had cancer and that the cancer was really hard and sad and it made you really sad and your family sad. I'm mostly just interested in you had cancer and it cost a lot of money and then we can give you a discount on the debt potentially because our creditor will allow it.
Yeah. Yeah. I think that I tell clients often my job when I'm trying to negotiate a settlement is really to paint a picture for the creditor and really kind of do the creditor's job, allow them to take, I'm dealing with attorneys often, but to help that attorney, the creditor's attorney, really sell this proposal to their client. There's got to be some reason why they should take less. And I always try to view it through a lens of how difficult is it to collect against you? You're a consumer who has a debt issue. Is it something where you have a real high paying job, you own a bunch of real estate, if there's all those things that you have that would be easy for them to go after, they're probably going to be less inclined to take a settlement. But if you're on Social Security, which is protected under federal and state law, they can't garnish it. If you don't own any real estate, if there are some medical issues, those types of things I think are good to bring up because they tell the debt collector, look, this is not going to be easy for us to collect in the long run. Maybe we better take what we can get now and just, get it settled.
Indeed. Great tips. Next question from Katina in Pennsylvania. I'd like to know if debt consolidation programs are helpful or harmful to consumers.
This is a good question. And I'll tell your audience what I tell people who call into my office. You're talking to a bankruptcy attorney asking that question. So I have my own biases. But a lot of it, I think, is understanding how these companies work when you go on to settle your debt through them. Usually what they do is they'll set up a payment plan. You'll start paying them. They're going to take their fee out of what you're paying each month. And then they put the bulk of it in essentially a savings account. They're going to build up a balance that they can then reach out to your creditors and negotiate. So I've seen it work for people who have relatively few creditors. If you come in there, you have 3 or 4 credit cards, $20,000 in debt, you're able to put a significant amount. It's something that can happen fairly quickly. I've seen it be effective in those cases. Where I have not seen it be very effective is if there's a large amount of debt, or I should say, and or a lot of creditors. If you come in with a dozen different credit cards, often it's difficult for them to get everybody on board, or they're trying to set money aside from what you're paying them. And then they will go in and, they may be able to settle one or two, but then you get hit with a lawsuit from creditors 3 and 4. So I think it's really kind of case by case. Where I have personally seen it be more successful is where the debts are not extremely high and the creditors are less than a handful, where there's not a lot of different people that they have to try to negotiate with to get them all on board to make it really work for you.
Yeah. Yeah, folks, just laying out the landscape a little bit for you, Katina. There's a variety of options, right, for somebody who's in an extreme debt situation. One, you have bankruptcy, Chapter 7. That's where all of your debt gets deleted. You have to qualify for it. Bankruptcy, Chapter 13. That's where you get on a payment plan to pay back all of your debts. You can do debt settlement with like a debt settlement firm. That's where you enroll all of your debt. If you have any debt that's not in collections or in like litigation, you default on that debt. You stop paying the debt. You pay your money into an escrow account, and then the debt settlement firm will eventually settle for you, probably offer you a refinancing loan to pay off all of the debts at some point in time. And that allows them to get paid quicker, etc. So that's debt settlement. And then you have debt consolidation, which oftentimes is used kind of interchangeably, but I like to use debt consolidation primarily to refer to a loan that's refinancing other loans. So you can do debt consolidation. That's like where you get a personal loan to pay off like 3 credit card debts. And then you have one payment, hopefully at a lower interest rate on that personal loan. So that's like debt consolidation. You also have credit counseling. Credit counseling is oftentimes nonprofit service that you can find online where you have like a licensed credit counselor and they give you advice. You meet with them once a month, etc., etc. And that is a requirement for Chapter 7 or something along those lines. Is a requirement for Chapter 7 is doing credit counseling. With Solo, where we sit, is you can use us to respond to your lawsuits. If you're being sued for debt, you can use us to respond. And then we also have Solo Settle, which is not a debt settlement firm. It's doing something new that works well for the consumer and the collector, where we just connect you with the collector and make it easy for you to pay off the debt quickly at a discount. So whereas like a debt settlement firm, average time to settle is like 12 months plus, oftentimes up to 24 months before you actually get a settlement. With Solo Settle, you can get a settlement instantaneously. Average settlement is 11 days to pay off. All right, so that's kind of the broad landscape of offering here. You also have credit repair. The list goes on. You also have credit repair. So those are like companies where you'll pay them a monthly subscription, like $30 to $100 a month, and they will essentially just monitor your credit and send FCRA dispute letters to the credit bureaus for you to get stuff removed off of your record. Also, they'll help you like pay off debts that you owe. I think that's pretty much the landscape. John, did I miss anything? Is that pretty comprehensive?
Yeah, no, I think you really hit on really kind of all the different options, and that's what there is a lot of different things that you can do. Again, we always talk about taking action, choosing one and going with it, but making sure too you're putting your money where you're going to get the the most resolution for it. And so it's good to kind of really get a bunch of opinions as far as which way to go with it. But yeah, no, I think you hit it all.
Okay, great. Looks like we have somebody calling in to the hotline. I'm going to plug them in. How's it going? This is George.
Hello.
Hello. Yes, I can hear you.
Okay, great. Alana.
Alana, how's it going?
Good. How are y'all?
Doing great. You're live with John and George on the debt hotline. So go ahead and tell us about your situation.
Okay, so I had a credit card from Citibank that has been charged off with a total of $2,455. They sued me 3 years ago, I did not respond to the courts. I just thought, oh, well, I'm not going to go to jail, so why worry about this? Um, so now they have come back 3 years later with a motion for default judgment. And I'm wondering where I should go from here. They've sold my debt to a second party, and they're the ones actually like suing me, I guess. So I was wondering if I should reach out to the second party, should I reach out to their lawyers that sent me the paperwork, or what I need to do.
Great. Yeah, thanks for calling in. Happy to help you out with this. So it's you said it's a credit card debt with Citibank. You said the balance was around 20K. All right.
2,500.
Oh, okay, 2,500. Okay, nice, much lower. And you're sued 3 years ago. Now 3 years later, they are filing motion for default judgment. How'd you get into this situation? Like, what was the debt for anything in particular? Just kind
No,
of general
I
credit
would
card debt.
say young and dumb.
Young and dumb. Just
Yeah.
spending money. You buy anything cool?
Not really.
Nothing particularly interesting. Okay. And how are you doing now? Are you what are you doing for work? What kind of money you're bringing in?
I bring in probably about $3,000 a month, so still not much, but I'm actually doing the Dave Ramsey program, so I'm working on my debts. So I'm trying to figure out where to go.
Nice. So you're working on paying off your debts and becoming debt free. That's great. Glad to hear it. We are fans of Dave Ramsey's show, so that's great. Do you have any other debts that are in the pipeline here? Is this pretty much the only one in collections?
I think I have a couple more, but nothing that's coming against me like this.
Okay, well, good job getting to 3K a month. That's a great place to start, a great platform to work with. John, what's your take here?
Well, I mean, what I would look at is one. I mean, if they're filing for a default judgment, I mean, you want to try to avoid that if you can, because what happens when there's a default judgment is entered. Usually, I mean, that $2,500 that they're suing you for, you might see it. I mean, literally double. Sometimes they'll add pre-judgment interest, post-judgment interest, attorney's fees. And if you don't respond, if you don't file an answer to the lawsuit, often the courts they'll kind of interpret that as you're saying, okay, I'm okay with everything that they're seeking. And even the courts don't do a lot of digging into exactly what they're throwing in there. So I would recommend at a minimum trying to file an answer, even if they filed that motion for default. At this point, I would try to get something filed. Like George talked about, Solo does that as well. They can help you get an answer on file. And then you can try to negotiate it. Even if it's at the lawsuit stage, or even if the judgment's been entered, I can tell you I have worked with countless clients where the creditor is still willing to do some type of settlement, whether for lump sum, like on a $2,500 account, they might be willing to take. My just baseline is 50%. If you can settle for 50%, or even hopefully somewhat less than that. Or even a long-term payment plan. If you're doing Dave Ramsey snowball type thing, you may be able to work something into your budget where you can put that on a snowball as well, and they will agree to it. If they filed a lawsuit, sometimes they'll require something called a stipulated judgment, or sometimes we call it a pocket judgment, where they draft up a judgment, say, okay, you're going to pay $150 a month for this, X amount of months, and we agree not to pursue you on this judgment so long as you're making those payments. So you still have some options, but I would recommend filing an answer just to try to avoid that default. It's there's all these steps along the way where the negotiating power gets further and further to the creditor, and having a default judgment entered would be one of those. So that's probably the first thing I would do, and then try to negotiate something. And you're going to have to go through their lawyers at that point. If you call the creditor, if you call the original creditor, they're just going to give you a phone number that circles back to the attorney anyway. So I would just reach out to their law office.
Okay. So I guess I should say that I already did that today, and I put in an offer to settle for $500. Now, they did tell me that if they, it was accepted that I would just pay it, and as soon as their lawyers got proof of payment, then they would send that to the courts and say to dismiss the case. Does that sound right?
Yes, I mean that's typical procedure. The only thing I would be careful of, if they've already filed a motion for a default, the court's not aware that these discussions are going on between the parties.
Okay.
And so, if it's something they get back to you tomorrow morning and you got a deal done, then okay, you're probably okay then. Sometimes though, they take a while to get back to you. And if they do, to me, the safest thing to do would be to go ahead and file an answer. But you may want to follow up and say, hey, how quickly am I going to get a response back on this? Because if not, I need to file this with the court just so that you don't end up with the default.
Okay.
Yeah, clarifying a couple things for you, Alana. So who's the law firm on this?
Jenkins and Young PC.
Okay. And what state is it in?
Texas.
Okay, great. Yeah, so with Solo, so we, people use our platform to settle a lot of debts, especially in Texas. So you're welcome to make an offer to the collector via Solo Settle, and then we the software takes care of a lot of the process for you, and you can, once it's settled, you can pay the collector through the platform and protect your financial information from like some online portal where you would pay otherwise. So that's helpful. $500 on $2,500 debt, that'd be a pretty sweet deal for sure, especially for something that is this late stage. Usually the later things get in the process, the higher the required settlement parameters will be for the collector. So if it's like in litigation, now the collector spent a lot of money on the debt, so they aren't able to settle for as low of an amount. And so you said this was a credit card for Citibank, and the motion for default judgment was filed. John, is it a little bit weird that the default judgment isn't getting filed until three years later?
Yeah, I guess procedurally that's what I didn't understand. I mean, if the lawsuit was filed 3 years ago, and Alana, you can correct me, but if that does seem strange, because most courts, if the creditor is not pushing the case, they'll dismiss it on their own. So I guess that's the only thing you may want to just double check that there is, not a judgment already entered, and this is some type of post-judgment proceeding where they're trying to do a garnishment or something like that. But, or if they just recently filed the lawsuit, that makes more sense. If they filed it within the last 4 or 5 months, if they filed it 3 years ago, I would want to really look at the docket and see exactly maybe what's been going on here, why there's such a delay in this.
I think they just filed it August 12th of 25.
Okay. So that would make, if that's when they filed the lawsuit, that would, then they wouldn't be, if that's the motion for default judgment, I guess we'd want to find out when they filed the actual lawsuit.
Still 14 days. I think it's 14-day deadline in Texas.
Oh, okay. That's quick.
Okay.
They want you to respond quickly in Texas. Yeah.
Yep.
So that may be, that
But,
could be an issue.
So what happened 3 years ago, Lana? You were saying that maybe they had sued you 3 years ago?
Yeah. Honestly, I was just like, oh, it's a little bit of credit card debt. I mean, everybody has that, so why worry about it? I was just young. So
But they actually sued you? Like they sent you a lawsuit and you lost the lawsuit 3 years ago, do you know? Or did they just try to collect from you 3 years ago?
I think they may have just tried to collect from me. I know the constable brought it to my house, so I thought that was kind of weird.
Okay. Yes, what I'd do next is you can gather up all of your documents. And then you can use our Ask Solo feature on our site. You can upload all of those documents and then chat with Solo to get tips on like what these documents mean exactly, so you can get a better understanding of your case. I think some things aren't necessarily adding up for John and I, in that sounds like either you were sued 3 years ago and now you're receiving a writ of garnishment and they attached a motion for default judgment that was already granted, or they sued you recently and they sent you a proposed order for default judgment, which can't be like filed yet really because you haven't let your deadline to respond lapse. So I'd take all those documents, take pictures of them, upload them on the Ask Solo chat, and get some tips from there. All right, Alana, thanks so much for calling in.
Okay, thank you.
Thank you. Great. So folks, if you have a question, you can jump to the front of the line by calling in at 801-613-8181. Looking at the next question from someone who wrote in ahead of the show. Amanda in Ohio. I have about $20,000 of debt. I have been contacted by email and text by some collectors, along with the threats of being sued and being a criminal. I have set up repayments with a few, but not all. My wages were being garnished for one debt, but since I switched careers, I haven't been able to get in contact with them. I'm afraid that I'm going to jail, or my pay will be completely gone. I fell behind due to job changes and lower income. I need advice of any kind to help. Thank you. Quite the situation for Amanda.
Okay, so 20,000 in debt. There was a garnishment in the past. Did I get that right? And then, sorry, I'm keeping notes here. And then potential. The one thing that stood out is there's no jail. So I do tell people that. I always say we always go to this horrible place in our mind, particularly like, Alana said, the constable's coming to the house, and it's really invasive, that this is all happening. These are civil, claims that they have. And so, $20,000 of debt, I mean, it's a good chunk, but it's also something that can be dealt with a number of ways. I mean, you can, I always say, if you're going to look at a settlement option, I always say, you just write them down and let's see who's being the most aggressive. Who's going to cause the most pain first? Is there a lawsuit that's filed? Then let's deal with that one first. If it's something where they're just all kind of out there calling, emailing, that kind of thing, it's important to remember until they get a judgment, there's not a whole lot they can do to you. They can damage your credit score, but they can't garnish your wages. They can't take any, lien your house or anything like that. So if they haven't filed a lawsuit, often they're pretty noisy and intimidating and annoying because that's kind of the tools that they have to try to get payment. You still have time to try to negotiate it. If it's something where, things get totally overwhelming, I mean, there is a bankruptcy option. Chapter 7 bankruptcy eliminates these debts completely. But if you're trying to avoid that, like I said, 20,000 is 20,000, but at least compared to what I see every day, that's something I see that a lot of people can manage over time. But I would prioritize who you're going to deal with first, and then attack that. And I prioritize that again by who's causing the most pain at this point. Who is it who's closest to filing a lawsuit or who already has a judgment? Those types of things are kind of how I approach it.
And going back and clarifying something that John said for you, Amanda, you don't end up in jail in a debt lawsuit because it's a civil matter. So it's dealing with civil law. It's a different section of the courthouse, like kind of entirely. Whereas the only stuff that can put you in jail is criminal law stuff, generally speaking, right? So you go to jail for criminal offenses, like you did battery, you assaulted someone, you can go to jail for that kind of stuff. But this is in civil law. Jail penalties are not available in civil law. So like what can happen is you can be told not to do something, you can get an injunction. That's where like the judge slaps you on the hand and tells you to stop doing stuff. You can get monetary damages. That's usually what is awarded in civil cases. That's where the judge says, you have to pay the collector all the money that's owed. Does that sound right, John?
Yeah, and the only exceptions to the jail rule, and they're minimal, and that's why I usually don't even bring them up. One, taxes. If you don't pay your taxes, and even then, truthfully, it's very, very rare. The other one is what we call domestic support obligations. If you have child support, spousal support, you don't pay that. Eventually, you could find yourself in jail. The third one is is if they have a judgment, if a creditor gets a judgment against you and the court orders you to come in and to provide information on assets, and you just ignore that, then the court could hold you in contempt for ignoring their court order. And so again, the underlying theme of everything is engage, communicate, participate. It's when you ignore stuff like that at a very, late part of the process where I've seen it become a problem, because the court can hold you in contempt for not following their orders, and they can issue a warrant. And I've had that happen for clients who don't show up to different things. Those are very, very rare. Just because you defaulted on your credit card doesn't mean, that one of their remedies is putting you in jail. It's really just they're trying to collect money, and it's a completely civil matter.
And usually when you hear stories about this, about debtors going to jail, that's what people are reporting on. It's a bit sensationalist, but they're reporting on people going to jail for violating a warrant and being held in contempt of court. That is where that comes into play. But there's no debtors prison in the United States. Folks, just wanted to show you some stuff on the website, right? So if you've been sued for debt, you can come over here, go to solosuit.com, and just click the reply to a debt lawsuit button, click the get started button, and then you'll just answer a few questions on here, and you will be right along your way to responding to the lawsuit. And once you get done with that, you can settle a debt. You can make an offer to the collector to get things settled. So prioritizes maintaining good relationships with collectors so that we can just help everybody get to an ideal settlement as fast as possible. If you have any questions that we haven't answered, you can just come on to here, and you can ask your questions right here in the solo chat. You can ask things like, how can I build my credit? And you can get tips tailored to your very own credit report and get those things figured out. So go ahead and try out Solo if you haven't already. We have a couple questions here in the chat. We have one from Golden Child. What if you were a victim of identity fraud, but the debt collector is still trying to sue?
Yeah. So, when I have clients who come in and say, hey, I'm getting sued by this creditor, it's an identity theft situation. This, again, is important to communicate early on. I usually will, even before I file the answer, I'll just pick up the phone, call the other attorney and say, hey, this is an identity theft issue. Could we get an extension on filing that answer while we try to work this out? Sometimes I know that's difficult for self-represented people. And so you may want to just file an answer and include that as one of your defenses, that this is an identity theft issue. Most law firms, what they will do is they will provide you, they call it an identity theft affidavit, which is sometimes each law firm has their own version of this, but a lot of creditors have this. And it's kind of a two-edged sword. They do require you to provide a lot of information about you personally. A lot of stuff I'm kind of uncomfortable with what they want to provide, and I don't provide it. If they're wanting to know all of your personal financial information, I don't provide that. But they're going to want to know kind of what the facts surrounding the identity theft. They're usually going to want to know if you know the identity. Unfortunately, a lot of identity theft that I see is actually by other family members, that may be using people's identity theft or like their social security and things like that without permission. So it does get kind of a little bit tricky, but I make it known early that there's an identity theft issue, and then but you are going to have to provide some information. I usually recommend people go and file a police report if there's been an identity theft issue. And usually I can tell you the police, they take it, they write it down, and they don't do anything. 99% of the time they don't do anything. But it helps to be able to show, hey, look, I did this, particularly if you file to get the report done before somebody ever sues you about it, just so you have it, so you can say, look, I already filed this. This is an issue. And I have seen when you fill out that affidavit, if you can provide a police report showing that there was an ID theft issue, in my experience, the creditors drop it. The burden's on them to prove this case. And if you can come in saying this wasn't me and here's the steps I took to be able to show that it wasn't me, A lot of times they'll just drop the case and move on to the other. It's not guaranteed, but that's been my experience.
Okay, great. Thank you for those tips, John. We have another person calling in. And then this will be our last caller for tonight. Will, you are on live. This is George with the Outline. How's it going?
Hey, good. And yourself?
Doing great. Tell us
Good.
about your situation.
Yeah, so I recently replied to a debt lawsuit. I actually went through solo suit for this. I had initially listened and watched some of John's videos that he does on responding to these lawsuits in terms of going one by one through the allegations and whether you deny or what have you. Long story short, I denied all the allegations based on Solo Suit's recommendation. And so I guess my question is, what can I expect now that I've responded to it? I assume that it buys me a little bit of time to negotiate a better settlement with the creditor. Just kind of curious. This is the first time I've actually responded before settling. I had a number of other suits that I settled before I even got to the answering deadline. But just kind of curious, in your experience, what does that settlement look like at this point?
Okay, yeah, happy to weigh in on that. How did you get into this situation? There's some life event that led to this debt?
Well, truth be told, just kind of over our skis on a number of things, and so just couldn't keep up with the payments at a certain point, and we did have some medical things come up that kind of depleted some of our savings. So it was just a combination.
Yeah, sorry to hear about the medical situation. Yeah, that's oftentimes what happens in this situation is people have large medical bills that come up, and then what that turns into is credit card debt. There's not necessarily like an unpaid medical bill. People will pay the bill and then end up with credit card debt as a result.
Yeah.
So glad to hear that you used Solo to respond to the lawsuit. So that's the right first step. Congrats on doing that. We call that Solo step 1, is just responding to this lawsuit and getting that thing out of the way. And then for most people, what we point to is then Solo suit or Solo step number 2. Let me go ahead and share this with you here. So step 1, respond to your lawsuit. Step 2, settle your lawsuit. Step 3, settle all of your other debts. And then after that, you can kind of start making getting things right in track, right? Save up $1,000 stash or emergency fund, complete your legal foundation, do some great things like that. So for most people, the best outcome is going to be to settle. So if you recognize this debt, you're familiar with it, probably the best outcome is just going to be to make an offer to the collector on Solo settle and try to get a resolution in place. John, what are your thoughts?
Yeah, Will, what state are you in, Will?
Nevada.
Nevada. Okay.
We're good.
Each state is a little bit different in the procedures. I mean, the fact that you filed the answer is, it's a great first step. We often talk about 95% of people don't do that. And so you're way ahead of the game already. Most states will then have, 30, 40 days later, they're going to provide you with their initial disclosures. So they're going to provide you with any documents or evidence they have. And then there may be like a court hearing called like a pretrial conference, or they may file something called a motion for summary judgment. All of that is, we're looking at least 30 to maybe 120 days down the road. So the good news is you can take those steps, that George is talking about. I think now is a great time to reach out, try to get that settlement, proposed to them before there's something like a motion for summary judgment pending. There is a little bit of a lull here because, it does give you a little bit of breathing room, but now's a good time to reach out and try to get something resolved. Because if they file the motion for summary judgment, that's them basically saying, hey, judge, we don't need a trial. Just look at all of our documents and tell us if we win. Again, it's kind of that, there's always that balance that we're trying to get of putting yourself in the best position to get the lowest settlement possible. The sooner you do that, in my experience, the better deal you're going to get overall. So you did the first step, great. And I would immediately jump in and let's see if you can get something settled with it.
Yeah, fair enough. I think the situation that I'm in is I had a number of creditors come after me, and I've basically depleted all potential funds in settling all those other suits. And so this was the last one, and so now I'm kind of trying to buy some time so that I can negotiate that at this point.
How big is the debt?
This one, the last remaining debt is for 7970, so less than $10,000.
So 7,900.
Correct. 7,970.
Okay.
Yeah.
Who's the creditor?
Congrats on wrapping up all the other debts. Yeah, who's the creditor?
The creditor on this one is Citibank through. Do you want to know the attorneys?
Yeah. Yep. Who's the law firm?
It's through the Moore Law Group.
Okay. Yeah, a lot of people get resolution with Moore Law Group through Solo Settle. We see them quite often.
Yeah.
Something that might help in your situation, right? So a lot of people, sometimes people will settle on a lump sum payment plan. So you have like $1,000 debt. Somebody settles it for a one-time payment of $600. On the other end, people will do monthly payments over a long period of time.
Yeah.
Right? Most collectors
I've done
will
a
accept up
combination
to 36 months.
Yeah, I've done a combination of both of them on the previous
Yep.
settlements.
Yep. So maybe like a monthly payment plan for 80% of the balance over 36 months might work well for you. Most collectors will go down to like $100 a month payment as well. Sometimes they'll go for like a tiered payment plan, something along those lines, but certainly filing the answer is the right first step. Okay, Will.
Okay.
Fantastic. Thanks so much for calling in.
Thank you.
Thank you. Great. Yeah, and folks, yep, Solo Settle is a great option. We just had one soloist settle a $120,000 debt for $60K just last week. So they deleted $60,000 in debt in just a few days. So that's a fantastic win for them. So debt settlement really can be a great tool for getting back on the right track, getting your feet underneath you, and economic mobility. All right, folks. So just wanted to share, and wrapping up tonight, just want to share our solo steps one more time, right? So first step is respond to your lawsuit. Step 2, settle your lawsuit. Step 3, settle your other debts. Step 4, make a 1K stash and complete your legal foundation. Step 5, automate investments into index funds, right? So if you guys are listening in and you've kind of resolved all of the debt that's coming at you, or if you're like Will and you're about to get the debts that are in collections wrapped up, right? You can start thinking about saving up again. A great way to build wealth is to automate investments into index funds specifically. And that's just a great way to take advantage of stock market growth across all publicly traded companies, because real wealth is in ownership, right? Lawyers get wealthy because they own part of a law firm. Business founders get wealthy because they own part of a business. Some people get wealthy in the stock market because they own part of the businesses that they're trading, etc. Then step 6, boost your credit score to 800. All right, a lot of people on solo are in like the 500s, sometimes even lower. But you can get back up into the 600s, 700s, and 800. And then step 7 is prosper, become a millionaire, right? At Solo, we want people to grow their net worth and become wealthy, and we're here to help you every step of the way. John, thanks so much for coming on to the show.
Yeah, thanks for having me again. It's been great. Great questions tonight. Appreciate it.
We are getting into football season. Go Cougars.
See how they do this year. You never know. It's always hit and miss, but go Cougars. We'll do it.
I think it's going to be a good year.
Yeah, I think it'll be good. Basketball will be really good. But football,
Basketball will be really good.
yeah. Well, hopefully football will be good as well.
Nothing else. The Cougar corn and the Cougar tails will always be good.
Cougar tails are always good.
Yep. All right. Thanks for showing up, folks. Everybody